This is the recording of the lecture that would have been given on Monday, March 22nd, that I dispersed to give you guys room to go and continue working on your con law assignments. So, to get started, today I've got some administrative things to go through, and then we're going to start talking about nuisance. So, administrative notes at this point, I am about 3/5 of the way done with reviewing your midterm exams. Once I'm done reviewing them, you will get an overview document that will explain the correct answers to each question and give you rubrics for the marks that you received on the short answers. So if you want to discuss your marks, there are some things that you have to do. And this information on this process will be included with the overview and with the rubric, so you don't have to worry about remembering this. This is just for your information. The first step is you have to email me a written explanation of what about your grade is confusing to you or what you are struggling with. And this explanation needs to refer to specific questions, their explanations, and the rubric. And it really needs to not exceed more than 500 words total. Okay? At that point, you have to make an appointment to spend 10 to 15 minutes with me to discuss your grade. And these appointments will not be occurring during office hours, so you have to make an appointment. You cannot just drop in. I don't hold grade discussion meetings for the first 3 days after your marks are returned, and that's intended to give you time to review your answers, compare them to the overview document, and to identify the places where you're still confused. One thing that I want to note is that, you know what, I'm human, I make mistakes, so I don't alter grades based on you saying that you feel like your answer should have received more marks. If I treat the same answer differently for different students, I'm open to fixing those sorts of things. I'm also open to correcting everyone's grades if I'm convinced that the question itself is a problem. In fact, to be perfectly frank with you, I've already spotted 2 questions just in these reviews where that is in fact the case, where I feel confident that I wrote a bad question and you'll be getting those marks back. But one of the things that I want to emphasize is that you get one opportunity to address these sorts of things. So once you make an appointment to discuss your grade, after that appointment, no further discussion on the matter will be entertained. And one of the things that means is if you forget to show up for your appointment, then here endeth the discussion, okay? With all of the above said, I will not regrade your exam during our meeting. So if we decide that there's further review of some sort of issue, I will do that outside of your presence. Okay? So these are the things that you need to know about sort of where you stand on the midterm. And with that, let's move on to nuisance. So nuisance is, I like to describe it as the tort of get off your lawn. So you're all familiar with the stereotype of the old man shouting, "You kids, get off my lawn." Well, nuisance is the old man shouting at his neighbor, "Get off your lawn." Okay, so there are ways in which to use your property that are entirely lawful, entirely permitted, but they are actionable in tort because they impose costs on others. Okay? So the most basic theory of nuisance is the idea that we should internalize the externalities that come from your actions. And you may be asking, what's an externality? And this is why, it's why law students should take microeconomics, but that's a different conversation. An externality is a cost that is imposed on someone else for your actions. So you get the benefit from your actions, someone else pays the cost. Okay? The classic example of an externality is air pollution, right? The polluter secures the benefits of engaging in whatever polluting activities they're engaging in, whether it be driving a car or running a power plant or whatever, but the people who pay the cost of that in the form of lowered air quality are everyone, right? And only the person who is doing the polluting secures the benefit of it. So one of the things that's really important here is to keep in mind that nuisance cases are extremely fact-driven, right? We've been talking sort of across the course of the semester that there are some places where the analysis is fact-driven and it can be difficult to determine sort of general principles. Nuisance is an example of an area of law where that is extremely the case. But the courts, the commentators have identified three things that seem sort of common to a lot of nuisance analyses. The first one is the nature and extent of the interference. So what is the externality that's being imposed on people, on the plaintiff, right? What is the cost that is being imposed on them? Is it an enormous cost, or is it more de minimis, right? Is it something that may be aggravating, but you should just learn to live with it or go somewhere else? The second thing that we see in a lot of nuisance cases are discussions relating to the character of the neighborhood. And I want to flag this one for you because this is an issue where class and race play a really important role, because the character of the neighborhood is a polite way of saying that poor people don't need to have nice things. That we can, do whatever we want to poor people because whatever, they don't need anything. So this is something that I would encourage you to think critically about. Why do nuisance analyses focus on the character of the neighborhood? And what would it mean if we imposed nuisance liability on actors, right? Whatever they are, and I'm being generic about this for a reason that will become clear in a minute, okay? If we impose nuisance liability on tortfeasors in this circumstance without regard to the character of the neighborhood, what does that do for the society that we live in? What sorts of things become more difficult, right? What sorts of socially desirable activities might we give up in that circumstance? What sorts of socially desirable activities might we engender in those circumstances? These are things that I would encourage you to think about. The last step in the analysis that the commentators have identified relates to the reasonableness of the defendant's conduct. And what this essentially boils down to is the court asking the question, do you really have to do this here, right? is this an activity that cannot be undertaken elsewhere? And this is why a lot of successful nuisance cases have to do with the building of slaughterhouses, or perhaps more controversially in 2021, the building of brothels, the building of factory farms, right? These are activities that don't necessarily have to be undertaken in a particular location. There are other nuisance cases that relate to things like encroaching plants and sort of trees that are growing across a property line, and those cases can be more difficult to win because, well, the tree is growing where it's growing. It's not necessarily reasonable to ask the property owner to move the tree, okay? So that's where the reasonableness of the defendant's conduct comes into play, and why some types of nuisances are more likely to lead to liability than others. One of the things that I would encourage you to think about is to think about alternative ways to force property owners to internalize externalities. Tort liability is only one way in which we do that, and there are problems with that as an option, right? One possibility might be to encourage the use of regulation. So, for example, right, we don't necessarily have to regulate in the form of requiring polluters to scrub their pollution, right? So one issue that we have with water pollution, right, is the issue of industrial plants that use water in their processes, building next to a body of water, right, a lake or a river, having their intake come in, and then expelling their waste into the same body of water, particularly if it's a river and there's a flow that sort of carries their waste away from them. One regulatory response can be to require that intakes be downstream of exhausts. And so any waste that the polluter puts into the stream, they then are pulling into their factory through their water intake. This doesn't solve all of the problems with water pollution. Obviously, this is a very complicated policy issue, but it's one way that accomplishes the same aim as nuisance, but doesn't require all of the rigmarole surrounding a tort liability. Another option is political organizing for collective action, right? Consumer collective action in the form of a boycott, or worker collective action in the form of a strike. Now, there may be issues where national law in some way prevents those sorts of collective actions, and also there's the usual political obstacles to collective action. Those are issues that we're not going to discuss in this class. They're sort of beyond the scope of everything in this class, but they are real, and so they do present obstacles to that, but these are options. So one of the things that I want to encourage you to be thinking about is nuisance is sort of a difficult tort to prove, and it also presents a lot of issues where a legitimate nuisance may never lead to liability, because of some of the procedural obstacles that we're going to talk about this week and next week. And so, are there alternatives that can be more effective at accomplishing the policy aims that nuisance liability attempts to accomplish? In order to evaluate this, we have to discuss what are the types of nuisance and how do they come into play, okay? And there are three types of nuisance. There's, just to dispose of it very quickly, there is a statutory nuisance. And essentially what this is certain statutes create a private right of action to enforce certain types of regulations. And a lot of these are environmental regulations, not all of them, some of them are consumer regulations, but in general, they are just private rights of action created by statute to act sort of in the place of the regulator. They are not a subject of this course. We will not be discussing statutory nuisance, so I have now said everything I'm going to say about it. The other two types of nuisance that we will be discussing in this course are public nuisances, which are externalities imposed on the public as a whole, and private nuisances, which are externalities imposed on some specific property owner. Okay? So, for the rest of this recording, I'm going to explain what makes a public nuisance and sort of how these cases are particular and unique. Okay? The specific thing that makes a nuisance a public nuisance as opposed to a private nuisance is that the people who are harmed don't have to have any sort of property interest that is being harmed by the nuisance. So public nuisances are things where people who are just out living their lives, right, and the externality that the nuisance creates prevents them from doing so. They can't live their lives the way that they normally would, and so that is the public nuisance. But the problem with public nuisance cases is that the claim of the public to the right to enjoy their lives can only be brought by the state. So the Attorney General has to bring a public nuisance action. The only exceptions, there are two. One is where there's a statutory nuisance claim, right? So there's some statute that authorizes a private right of action. And as I said, we're not going to discuss that any further. And the second exception is if the private plaintiff bringing the public nuisance action has suffered some sort of particular harm that is different from the harm that is imposed on the general public. And the question that then arises is, what is a particular harm? What is the harm that is imposed on the plaintiff as opposed to the harm that is imposed on the general public? Does not mean, right, I want to be clear about this, it does not mean that the plaintiff has to have special damages or the plaintiff has to have some sort of economic loss that is particular to them. It just means that they have to have some sort of harm that can be differentiated from what everyone else suffers. So the classic example, the classic case of the particular harm analysis is actually from Guyana, and it's related to a case where a bauxite mine, for those of you who don't know, who've never had any exposure to metallurgy, bauxite is the raw ore that, after processing, produces aluminum, or aluminium, as they say in the UK. And so this bauxite mine had been producing, metal dust that settled across a series of farms. And it basically made the farms unusable. You can't farm on soil that's been contaminated by heavy metals. If the crops grow, they'll be inedible because they'll be contaminated. And so the farmers sued, alleging that the mine was a public nuisance and that they had suffered a particular harm. The court denies the claim because, and here's the puzzle for me, the court says that the farmers constitute a class that is the public, right? So we have a public nuisance, but none of them have suffered a different harm. They're all alleging the same harm, and so the claim has to be brought by the state. There's nothing particular about what they've suffered. If this doesn't make sense to you, think about where the resources lie. Who do you think is more likely to have the resources to fight the case effectively? Right? And we're not saying that there's anything corrupt about the decision. Okay, I want to be clear about that. We're just pointing out that it is known that entities and individuals with resources have more success in court without any corruption at all. So we're not alleging that the judges were bribed. We're just saying that the mine has the resources to fight more effectively. And so if this decision doesn't make sense, you should think of it through the lens of which side has more resources, and then maybe it makes more sense. But do you see how the particular harm has to be unique to the plaintiff? It cannot be something that the entire class of affected individuals is suffering. And another example, right? A case, I can't remember where this case is from, but essentially a construction project had rendered a street impassable, and the plaintiff was suffering an extended commute and was having to detour out of their way and to get to and from work. And the court said, look, we're all inconvenienced by this. We all have to find ways to avoid using this unpassable street, and so you have not suffered any particular harm. The fact that your harm is perhaps greater than others does not change the fact that we all are suffering the same harm. Okay, so this is how public nuisance works. And I'm recording this Wednesday morning, so on this afternoon we're going to talk about how private nuisance works and sort of examine the differences between them. So with that, I hope that this lecture is helpful to you, and I look forward to seeing you guys this afternoon. Take care.